Okay, hello everyone and welcome. I'm Julietta with Rixera, your host for today's webinar. Across the real all the information getting any specific legal concerns or questions you have regarding this new buyer's ruling. The views expressed by our panelists are their own and not necessarily a reflection of the views of our respective organizations. So let's kick it off. We're going to introduce our panelists. Each of them brings a wealth of expertise and a unique perspective on the real estate industry. First, we have Mark Sterbcow, managing attorney at Sterbcow Law Group. If you want to say something quick about yourself, Mark.
It's great to be here, and thank you guys for the invitation to speak. Look forward to today.
Thank you. Next, we have Mark Krein. He's still getting on, but he's the managing partner with House Karma, CEO at RIO Software Solutions and president of the National REO Brokers Association. And finally, we have Mike LaRosa. Sorry, I'm reading the wrong scene. COO of Florida Agency Network. Do you want to introduce yourself, Mike?
Hi, everybody. Thanks for having me. I hope to provide a title perspective for today's webinar.
Perfect. Michael, we already introduced you, but if you want to go ahead and say hi to the group, you are more than welcome to.
Well, I appreciate it. Thank you, Julietta. Marx, you I know forever, so I'm not even going to talk to you. Mike, nice to meet you. And happy to be here.
Now to start off, little concise explanation of what we're discussing today. I know most of us have heard about it everywhere, but basically the new Buyers Commission ruling mandates that buyers agents must negotiate their compensation directly with their clients instead of relying on offers from sellers on the MLS. Now, this will foster more transparent and competitive pricing, and we're going to dive into what that exactly means. So first off, for our panelists, we're going to start off on the implications for buyers, sellers, and real estate agents. Questions that people have been asking: how does this change the buyer's financial responsibility? What strategies can they use to navigate this? What seller obligations are we seeing? And what can agents do to negotiate these new structures that they're seeing?
Mike, you directing the question to?
Mike, why don't you start off?
Well, I was going to say, you guys are going to be more technical than me, but from a title perspective, from a street level perspective, I think we're anticipating the proliferation of mega teams. At least that's what we're guessing at this point. More of a listing focus with buyer side agent support as part of the team. Maybe a shared commission structure coming down the pike. But I do believe that right now about 40 states are buyer directed, and so it varies state by state, and it'll take time to evolve. But I think that a seller directed model certainly seems more likely. I think with that, you're going to have an industry that is looking for ancillary income. There's commissions lost that's going to have to be made up somewhere. In my world, I believe that a lot of that's going to come in the form of affiliated business arrangements, ABAs. I'm already feeling that, certainly getting a lot more calls on that, and that's something that we specialize in at the Florida Agency Network. And one word of caution, I would say, with affiliated business arrangements, with more of them is going to come greater scrutiny. I think realtors out there need to focus on legitimate ventures that are fully capitalized, standalone entities, capable entities, no financing through loans from partners or distributions. But I do think we're looking at more of a consolidation.
Consolidation is probably an understatement. Marx, I'm going to, okay. Been doing this for about 35 years, from owning franchises in regions to REO and default, you name it. Marx and I had actually had a conversation on the sub-agency days years ago, not to look too old here. But I think I'm going to leave the legal aspects to Marx because I frankly don't care. Okay, what's really happening here is the changing consumer behavior. Okay, consumers are now becoming aware of how much these buyers agents are making. They're also becoming aware of how poorly qualified some of these buyers agents actually are. All right. It used to be they didn't have a choice. They do have a choice. They're becoming aware of it. And the problem you really have is you've got a young couple or a first-time home buyer struggling to get a 3.5% down payment. And now you're telling them that they have to come up with another 3% to pay a buyer's agent to represent them. And in many cases, these buyer's agents, their entire credentials are a 40-hour online course and $69. Some states, that's how easy it is to get a license. How do you explain that to the consumer? How do you justify, with the average sales price of $400,000 plus, that they've got to come up with another $12,000 to have somebody help them get a house? Okay, consumers have access to the education, the tools. The analogy I like to use is buying a car. If you go into a car dealership, you comparison shop, you look online. I mean, let's face it, the buyer finds their own house at this point, not the agent. Okay, they can find it themselves. They negotiate price at a car dealership. You negotiate insurance, financing. There is title paperwork. Granted, it may be a little more complex, but how come they don't hire somebody to help them go buy a car? This information is online. The consumer now knows what they're paying for this. And you're telling me I have to come up with 2 down payments? That's where the real issue is. The legal aspects are, to me, are basically irrelevant. Okay, because whichever way it's permitted to be done, it's going to be done. But the real issue is the consumers are educated. You mentioned in your opening statement about the transparency. Yes, consumers now know what these things are and what they cost. They also know what they should be getting for what they're paying for. You know, especially with the first-time homebuyer market in Gen Z, these people are incredibly literate when it comes to the internet and researching, and they read. Financially, they're more conservative than the millennials, and they're looking at this saying, why do I need this at all? One of the interesting things we found with the broker network we run, and I have about 500 brokers, and I don't even know how many agents they each have under them that work within our group, is what's the word I'm looking for here? A massive increase in buyers going directly to the listing agent versus having a buyer's agent first. All right. And that's where the change is going to come. So for the people in the real estate industry, as realtors or real estate agents, I don't want to use the term realtor because it's trademark and I'll feel like getting sued today. They're going to have to justify their value for the first time really in their lives.
Yeah.
It's not a given, hey, I have to use an agent or a broker. You don't, and people are figuring that out. So that's where the change is. Again, it's going to come down to consumer behavior and how much education these consumers get and how fast they wise up. That's the reality we're dealing with.
Yeah, I would add on, I think there are 2 important components to the NAR settlement. So you have the settlement itself and the changes that are happening from that angle. But there's a much bigger change taking place on the internet. And that change is the seller directed websites that are coming on. So, and I'll give you a little bit of a historical perspective on that, and then I'll kind of dive a little bit more into it. But in 1986, the first real estate brokerage put all of their MLS listings online. It was before Prodigy, before CompuServe, before AOL, system called GEMS. And so how do I know that? My dad was the first to actually put all of our brokerages listings online back in 1986. So our company kind of controlled the internet. We were the Realtor.com, the Zillow, the Trulia, before those companies even came into the market. And at that point, from about 86 to about 2000, the brokers really kind of controlled the data. Around 2000, you had, the new upstarts with Zillow, and Realtor.com was around, but it was dysfunctional. But you had a bunch of these different aggregators coming in, and they really kind of became the new facilitators of a buyer lead program. And now you're seeing, that would be, I would call Real Estate Web 2.0. Now we're getting ready to hit Real Estate Web 3.0. And Real Estate Web 3.0 is being led by homes.com. And the your listing, your lead is enormous for the industry. And there's, if you talk to brokers across the United States, you talk to lenders across the US, they're all seeing the impact of homes.com right now. And I don't represent homes.com, but I see this new iteration. That model is what's going to help precipitate this new buyer to directly to the listing agent model. If it just has it has the components to where you no longer have to worry about the aggregators basically setting up or matching up a buyer with a buyer's agent. Now they know who has the property. They're going to contact them directly. They'll either contact them directly and have them represent them in some capacity, either through a dual agency or dual brokerage piece, or they'll go unrepresented in many cases. And so that's the big area that I see from the second aspect of this. The first part of it with as far as how the landscape goes, I agree with everything that Mike said. Both Mikes have said, Mike squared. I believe everything that they've said has been 100% spot on. The consolidation in the industry, it's going to happen. You're going to lose a large number of buy-side agents. It's not going to be immediate. It's going to be probably around 15 to 18 months post-NAR MLS changes, in my opinion. Most of these agents have no idea that there's even a settlement. They have no idea there are even changes, which to me is crazy. But the numbers I'm hearing and the numbers I'm hearing consistently across the industry is about 90% of agents have no idea about this, which is just astounding to me. But they have their own things that they're doing, and this hasn't crossed their desk yet. So with that, I think you're going to have a loss of that. You're going to have a loss of the real estate brokerages. And this is an important statistic. And this is from Real Trends years ago. The average real estate brokerage made between $250 to $440 per transaction pre-tax. So that's when you have the buy side and the sell side commissions coming through. Well, you're compressing those margins and those corporate dollars into the brokerage now. Well, now these brokers, if you're a buy side brokerage, man, you better switch yourself over to a listing brokerage, because that is really going to be economically impaired. And I see the same thing for the discount listing brokerages at the 1% list and things of that nature. I think that they are going to be significantly impaired, primarily because that model was based on a buy side commission structure. Yeah, I'll take the 1% on the list side, but I'm going to get 3% or 2%, somewhere around there on the buy side. Well, that's not going to be the case anymore. So you're going to have some real fundamental structural changes there. And that is going to facilitate and create a massive demand for affiliated business arrangements, whether they be mortgage, they be title, they be property and casualty insurance, or all three, and maybe some other types of ancillaries as well. That's kind of what I'm seeing take place. Mike did mention something about listing agents. I am seeing, and I have been seeing in talking with my brokerage clients, a significant switch from buy-side agents to morph over into listing agent teams. And these listing agent teams, the way that they are looking at their pricing, and this has nothing to do with pricing, I'm just kind of giving an overall perspective from a legal perspective of what I'm seeing, industry perspective. I'm seeing the listing agent teams charging a commission, it's 3%. I'm starting to see maybe in some cases a 4% commission from the listing agent, because they're doing more services than they were before. They're handling a lot more responsibilities than they were before. And then if in these states where there's dual agency prohibitions, and even in states where there's not, where the agent doesn't feel comfortable doing a dual agency scenario, these listing agent teams will be handing over the buyer to a junior level real estate associate that'll charge them a flat fee, $500 to $1,500, because that's about the max that most first-time home buyers, the average person, can actually afford to pay for a real estate agent. Because they have deposits, they have down payments, moving costs. I mean, they're already compressed. So that's about the max that I see there. I do see some other alternatives being done One would be, as I said, you have the flat fee model that's being developed. I have seen a per service fee that's in place. Problem with that is it sounds great with one home, but if you start doing multiple homes, multiple services, well, now the cost gets so outrageous that the buyer can't afford to buy a home. And the same thing with these hourly fees. So agents say, I'm going to charge an hourly fee. Well, it sounds great, but once you start running up that hourly fee, these people can no longer afford to buy a home, and they just sit on the sidelines. So I think that you're going to see, that flat fee model really take root on the buy side. And there'll still be some commissions where some sellers will be, paying a commission. Problem with that, and this is the big problem with the NAR settlement, is that it's no longer really protected under the cooperative brokerage compensation rule. So in the MLS, they had that cooperative brokerage compensation rule, and that was the catalyst for procuring cause. Procuring cause is what protected these agents from getting paid by the seller. And if the seller didn't pay, they had rights to go after them. Now
Let me
that's
jump on that, because that's
go ahead.
Yeah, I'd love to just touch on that one, but everything you said needs a whole hour for itself. That people aren't paying attention to. The procuring clause one is interesting because that's another thing we're seeing when you talk about these discount buyers agents. What they're doing is telling the buyer, go have the listing agent show you the house, then come back to me and I'll negotiate it for you and represent you. Well, under the procuring clause rules, which is most states, there's a couple are still meeting in the mines. That SBC, that selling broker's commission, you could make a claim and the brokers would fight it out, usually with their board. If there is no selling broker's commission, procuring clause just went out the window because there's nothing to go after. Yeah. So what we're seeing is buyers agents saying, yeah, I'll handle the contract negotiation for $1,000, considering it's maybe 90 minutes worth of work when you think about it. It's not that much paperwork. All right. For a very flat fee, but go have the listing agent do it. We literally just had this conversation where the listing agents are going to start requiring some sort of form before they show a house to anybody about that representation, because it's becoming quite a problem.
But this is the point. We're experts and we don't know exactly what the landscape's going to look like. And this is a concern for me. To Michael's point earlier, I'm wondering if there's going to be more buyers and sellers just entering the market unrepresented.
Guarantee there are. It's already happening.
But Michael, in my world, that's a problem. I mean, there are going to be issues, uncharacteristic issues. There are going to be delays that are going to have to, contingencies are going to have to be planned. And as this evolves,
you have a bigger problem.
Thanks.
For those of you who don't know, I own franchises, regions, title companies, and mortgage companies. The problem
in a state like Florida, where I am, it's still being debated.
Okay, my question is, from the title side, then, where are you generating your business leads from if it's not from the agent population? You depend on the agents. The holy grail of title has been consumer direct, because now we've got consumers going direct for the purchase of the property. We've got online loan origination. The holy grail for title is consumer direct. How do you get the consumer to choose you? Because you can't count on the agent giving it to you anymore as the title industry, nor can you do spiffs or anything else. They're so heavily regulated. I agree about your affiliated business arrangements. I had them all. The margins used to be fat. And yes, to what Mark said, the brokerage, the CCI to a brokerage is shrinking. But the CFPB and DOJ are coming down all over those. That's going to get tougher and tougher.
Yep. And that's a good point, because already we have such an, I don't want to say uneducated, but I feel like, a lot of the real estate industry is either not taking this seriously or isn't informed. That's why I love that we're doing webinars like this. I mean, I think at the end of the day, these realtors need to be realistic about where this is headed. I mean, there's no legislative guidance yet, right? The direction's going to take time. It has to evolve. It's changing. I mean, this has left the station.
The problem, let me say one thing, Mark, then I'll defer to you. The problem is you're dealing with all the different states with their own regulations.
Yep.
Those regs were written based on common and customary practices that predated the legislation itself. So you're going to have a new common and customary, and the states are going to have to adjust to this. And the lag time on that is what my biggest concern is. Consumer behavior will dictate all, but how the states deal with it individually is going to be really interesting to watch because of the licensing issues. So, Mark, sorry, I just had to get that.
No, it's okay. I was going to add one thing just on the procuring cause piece. With that being out the window, and agents thinking, hey, if you're a buyer agent, I'm still going to get my 3% or my 2%. I'll have the seller offer that in a concession or in a rebate that they'll give to me. That sounds all fine and dandy until there is a problem with the house, or the buyer can't come up with a down payment or come up with some money for the closing costs. And let's say we have termite damage, $40,000 worth of termite damage. The seller is going to go, you know what, that 2% credit or the concession I'm giving to the buyer's agent. No. Just apply that over to your termite, your damages or whatever, to those repairs that need to be fixed, or to lower the cost, something along those lines. Well, that buy-side agent and buy-side broker, they're done. They don't have any rights to go back after them. That's the most important piece that NAR and the local trades, local trade associations and even the big brokerages aren't discussing. And it's very important that people understand that this is going to be an issue. And if you're a buy-side agent, you put all this work into it thinking you're getting a 2 or 3% commission or 1%, you can get zeroed out at the end of the day. And, and then, let's say you have a buyer representation agreement to where the buyer is going to cover the offset. Well, how the hell are you going to collect that? Put a lien on the house?
Marks, run with that because there's a lot more to that. That's one of the most important things that could come out of this webinar as far as the real estate community itself goes. The problem you have now, if you do not have an offered compensation to the selling broker, they have to include it in the offer. You can't put a commission in an offer in a contract in most states. You have a fiduciary issue. You're representing the buyer, and if you're trying to work your commission into that price, you are now putting your interest ahead of your own clients. And I think there's going to have to be a huge distinction between what is a client and what is a customer. Mm-hmm. You owe fiduciary to a client, you don't owe it to a customer, which goes back to if the buyer goes direct to the listing agent and deals directly with them, the listing agent has the seller as a client, they have the buyer as a customer. There's no fiduciary to the buyer other than honest and fair dealings, obviously.
Yep.
But that's going to be a major issue because forget about enforcing it. You can't get it in there in most states. Mm-hmm. This is going to be fun to watch, guys.
Yeah, it's going to be.
It really is.
It will definitely be a period of chaos and carnage across the industry, the brokerage community. Because at this point, I don't care who settled. There's no way on God's green earth that any of these companies that have settled are going to be able to abide by the terms of the settlement agreement based on their agents' behaviors that don't understand this. And
well, I don't want to go.
Yeah.
So I don't want to go chaos and carnage, but I think, Mark, you're right. My friends and clients in the industry right now, I feel like they are expecting a workaround. I feel like they think the buyer's commission is safe. We'll find somewhere to put it. If it's not in the MLS, and we've already seen the DOJ is saying that they don't want these spinoffs to begin. You need to either start reinventing yourself or you're going to be in trouble.
Well, and you mentioned the DOJ. Look, the DOJ is going to be weighing in today in the Burnett case and one other case to discuss, in their intervention and the terms of the settlement for those particular cases. And I think that's one aspect of it. I anticipate that they're going to come out and possibly push for some stronger things. Getting rid of the lockbox rule will be one, where the MLSs are controlling the lockboxes. The second is making all of the data on the MLSs publicly available. Those are two things that I keep hearing repeatedly from folks that are directly in the know, and so having that aspect kind of moving forward in the industry certainly creates a lot more uncertainty, because if the judge doesn't approve some of these changes that the DOJ wants, well, NAR and the DOJ right now are relitigating the past settlement that they had entered into during the Trump administration. I foresee the DOJ right now, well, let me go before that. The settlement itself is a very disjointed settlement. It is not a consistent settlement across all 50 states. Really important to note. That settlement only impacted a few states. It didn't impact really the whole country. So although NAR is trying to make it sound like it impacts the whole country, there are a whole bunch of other lawsuits in other states that are still going on the seller side, antitrust parts. There's also buyer antitrust lawsuits, a big one in Illinois called Batten. So there's a lot of litigation. No one wants to talk about it. Nobody wants to go in public because one, you know what, if you're a brokerage, you don't want to scare your agents. If you're in line of sight, if you're NAR, the MLSs, the local associations, you don't want to scare everybody to death. So you try to keep, some little small, nice, clear, clean message that's been filtered 100 times without really giving the industry really what is going on. And I think that that it's important that people do realize that that these changes are going to be significant. The education component is going to be a very big aspect of this. The DOJ, going back a little bit, the DOJ and NAR, I think, is going to be the nuclear bomb. So that's going to be really relitigated. And I anticipate the DOJ coming in. And when I say the nuclear bomb, holding.
Mark, so you're talking criminal potentially?
Absolutely.
That's
Absolutely.
where I thought you were going, because that's nobody's paying attention.
Yeah, I anticipate the DOJ, it wouldn't shock me, given how aggressive they are, to hold members, executives at many of the real estate brokerages across the country criminally liable, the executives at NAR criminally liable, the members of many multiple listing services criminally liable, in order to put maximum pressure to get their new system in place. Because right now it's going to be a hodgepodge. Most of the non-NAR MLSs did not opt in to the settlement. Many of the major real estate brokerages over $2 billion did not enter into the settlement. I represent some. We didn't enter into the settlement. So, you have a hodgepodge across the country on this, and there needs to be some common stability. And right now they don't have it. And unfortunately, it's going to be NAR or the DOJ with a very heavy hand to come in to try to make the slate even.
Hey, Marx, back into something else you mentioned, because a lot of the brokers and agents are talking about this, and there's a couple companies trying to start these services. On a side note, guys, I own a software transaction platform. So we have a lot of communications between agents and managed transactions, and we're staying out of this. But there's a couple of firms that are trying to do this outside of the MLS. And you hit it earlier on total transparency of what the MLS published available to the public. Now, I'm assuming you're going to the agent-to-agent remarks, or as they're colloquially known, where they're going to put things like seller will consider compensation of X amount, things like that. That's what you're talking about, right? Because they think they're going to get around the MLS rules this way. And I think it's a bigger problem. And I'd like you to weigh in on that. Because a lot of people think they're never going to escape this. And I don't think so.
Yeah, I mean, I've seen that. And I don't want to comment too much on it because I do represent brokerages in the industry. I don't want that being used downstream, my words. But I have seen a number of illegal contracts that have been put out by multiple different companies or agents or whatever, with no real legal guidance or representation, or if they did have some, they didn't have antitrust counsel come in and review these things. So I worry about that. The other thing that I've seen is where you're seeing some people who are very creative say, we'll create our own website portal, and that website portal will show what the listing commissions are going to be from each side. I will tell you, having been to the Arello conference recently, which is the Association of Real Estate Licensed Law Officials, all of the states across the board said if they see something like that, they're gonna come down and yank licenses and impose significant penalties on those companies that engage in that.
Yeah, we were asked to add those features into our software by some clients, and we're just sitting there going, we're just walking. We don't even want to go near it.
Yeah.
I
And
agree
I
with
hate
that.
to cut you guys short on this one, but we have to move on to our next section of the webinar. So
But we
thank
were
you for
having
that.
fun.
Oh, I didn't realize there was an agenda. All right, here we go.
We have an agenda?
Hey, we do. I'm like, I need to talk to gentlemen, at least a little bit. Jeez. We're going to move on. I know a lot of people here are from the title industry. They want to know what implications are really for title and escrow. What are we going to see in the lending practices, the lending world? How is this going to change those instances?
There's something, I don't want to be a conspiracy theorist and go too deep down this rabbit hole, but, both gentlemen have talked about, there's going to be some shifting in representation potentially. And it's an odd coincidence maybe that various aspects of the real estate industry are being kind of disrupted at the same time. The discussions at the CFPB level, whether, buyers should even be paying for loan policies. Okay, I get it. They want to save the consumer money or give the appearance of saving the consumer money. But if lenders ultimately are going to have to pay for these policies themselves, I think logic would dictate that they're going to want you to use their title company. And I'm guessing here, but if that happens, well, how far is the next step? Because the origination process these days starts more with the lender than with the realtor. Is it impossible to picture lenders providing real estate buyer representation? Part of the process. You wanna borrow money. We will charge you a flat fee. Michael mentioned earlier, maybe flat fee models. And hey, you know what? Why doesn't the lender roll that fee into the closing costs? No money out of pocket. I mean, I could just see the potential for some pretty significant changes in the way we're doing business.
Yeah, I'll add this from your question. I think that let's say right now we have 10 different real estate agents that have deals that are coming through the table. And once these changes are put in place, we no longer have 10, we have 5. Well, that's 5 less referrals that are going to different loan originators, to different title agencies. And so you're going to see a consolidation, not just in the brokerage space and the real estate agent space, but also in the mortgage space and in the title space and in the title insurance underwriter space. I've been talking to one of the heads of one of the largest title insurers in the country. And recently he told me, he's like, Marx, we have 28 active title insurers in the United States. What we anticipate is after these changes come through, the loss of all these referral sources will be down to about 15 title insurers across the United States. So they're seeing that just on the title insurance underwriter side. On the title insurance agency side, I think he said there were between 13,000 to 15,000 title agencies across the United States. He sees that being halved as well. And then on the loan side, the same thing. I mean, you're not going to have all these different referral sources to come in. It's going to be a lot more consolidated, which isn't a good thing. But again, that's going to force, and it is forcing companies right now, the smart ones, to go out and get affiliated businesses and to try and get these ancillaries in place now while they can do it before it's too late. If you wait a year or 2 years, it's going to be way too late. You have to start planning now.
Can I turn my 2 cents in on that?
What was
Am I
that?
back in or not? Sorry, maybe it's fading in and out here.
Yeah, Michael, you're in and out a little bit, but while he's figuring that out, Mark, I feel like, and I don't want to go off topic, but it's related. You and I have both seen an increase in the demand for title alternative products. So you have lenders right now, specifically in the refi market, where maybe it makes sense. You're only coming forward from a year or two, same owner, not a lot of title risk. I don't know where this goes in the future though. But if they're going for attorney opinion letters or algorithm-based or soft credit pool-based insurance, well, not insurance products, but title alternative products, everything is being compressed. We're saving money, saving margins, origination fees. That's the downward pressure, Marx. That's where this consolidation, you're going to have to adapt or die. And in a lot of cases, that will require consolidation at the real estate brokerage level, at the title agency level. Mom and pop title agents, like small real estate shops, are going to have their work cut out for them if they want to survive in this ever-changing market. And I guess the reason to even mention that is things are changing. Whether you like it or not, the process is changing. The lenders are driving the bus, and service providers are going to have to adapt.
No, I don't disagree with you. Look, and it's important to note that the NAR case and now with the title insurance premiums, a lot of this is all political. So the reason that that NAR litigation really even got off the ground is that this was a fight between the AARP and NAR that had been going on for decades. The AARP, this American Association of Retired Persons, they wanted to come in and cap real estate commissions years ago. They filed a bill in Congress. NAR got it killed. And so they've always been very much. And so you have AARP, which traditionally gives a lot more money to Democratic causes. NAR has traditionally given more money to Republican candidates in Congress and the Senate and even in the states. So this was kind of the Biden administration's way to kneecap NAR and give a big win to the AARP and really kind of help them politically. So that's one aspect to it. And at the same time, NAR has been very dysfunctional the last few years. And because of that, it's considered weak. With that said, why are they going after title? Well, title, the Alta, nice people over there, but they are also considered very weak. They have no effective message. And so there's politics being played once again. So, this was so easy on the NAR side, but the real estate commissions, let's go after the title insurance part. The alternative product part, I think it sounds great in theory. I think in practice, any lender that does this will probably make money on the short term. The long-term exposure from buyback risk and from fair lending issues is massive. I would highly recommend any lender to really analyze this before they jump into these sorts of programs for the fair lending risk. I talked to Freddie, the head of Freddie, a while back, not too long ago, and asked him, I'm like, what's the average cost for these title insurance products? He's like, well, the average home price is $465,000. I'm like, well, that's certainly not affordable the way you guys are touting this out. I'm like, well, what about the attorneys? Are you seeing the attorneys increase their costs? And his response was, yeah, it's a real problem. We're seeing the attorneys, the fees are 2 to 3 times more than the title insurance premium would be. So it's going to create massive fair lending risk, a lot less protections for the lenders, for the investors, and for the consumers. So it sounds great in theory. I think it's going to be a limited duration that we're going to be going through this once people realize just the implications to their own bottom lines. But leave it at that.
As far as the attorney opinion letters, one of the things we're doing at House Karma is we're specializing in first-time homeownership creation. That's what we do. And when you look at any potential cost savings of attorney opinion letters, when you're dealing in the lower price ranges, it can actually cost more than the title policy. So why not just take a title policy?
Yeah, for less coverage.
It sounds great in theory, but in practice, it really doesn't save the consumer anything. I'm not against them personally. I'm not going to make a legal claim one way or the other, although I have an opinion, but that's beside the point. But there really is no cost savings when you're in the lower price ranges anyway. So you might as well just get a title policy.
And if funds are wired to the wrong, fraudulently, well, you don't have an insured closing protection letter to go in there to cover those products either. So there's a lot of things. Go ahead, Mike.
Sorry, I was just gonna say, but the lender will ask the agent, the settlement agent, the closing agent, to take on that risk. So again, you're going to be asked to do that with less money, less fees being paid. How are you going to cover the risk?
Well, what a number of insurers aren't covering it. Number one, there are some that do, but two, you have statute of limitations issues. Some states it may be 1 year or 2 years. So the average defect really doesn't pop out till about 5 years. So these lenders, who are they going to go after? There's nobody there to go after. So, and their investors are going to hammer them to come up with the buybacks.
Well, now this is, like I said, this is a refi product currently, so significantly less title risk. But if it's successful, you can't tell me that it's not going to start to creep into the purchase world.
They've
No,
already
no. The whole
started
point of
talking about
this was the whole point of this when they started this idea was to put it into the purchase. It was part of making out homeownership affordable. They're just testing it in the refi market. But no, it was brought out for that reason, to save costs to the first-time home buyers and the consumers. The thing is, it just really doesn't yet.
That's right.
No, that was its original intention. They made that quite clear when they introduced the concept.
But the politics involved in it are huge, and you know, you have to have effective lobbyists for these organizations on the Hill, and they have to get out a message to consumers. And right now, neither of these trade associations are getting these messages out. And primarily, look, NAR is embattled in litigation, and they're under, you know, they're playing turtle right now. They've got their head in because they've pissed off everybody in the industry, the brokers, particularly the brokers, but the agents, they're just trying to maintain right now.
I don't know how well funded they are, Marx, but I mean, at some point, I mean, Marx and NAR is fighting how many battles? I mean, this is an expensive endeavor.
NAR is the second largest political action fund behind AARP. Their funding was in the hundreds of millions.
All right. Well, maybe
And
not.
so far, they haven't seen a significant drop as far as dues-paying members. Although interestingly enough, they did stop publishing their numbers in March, so we don't know how many they have right now. That kind of, we were like, oh, okay.
Well, the other reason that NAR did this, and I was at an Arello conference recently, and one of the head legal guys for NAR came in, and he wasn't really aware of how the settlement would impact procuring costs in all of the states. He wasn't aware of how it would impact the cooperative brokerage commission rules in each state, which was crazy to me. You enter into the settlement thinking that, you know what the implications are. They had no idea what the implications were. Shocking. But the next conference I went to, the president of NAR came out, and the message was that everyone needs to join NAR so they can be exempted under the settlement. So really the piece is that they want, old Harriet over here that's done one transaction in the last 5 years to now join NAR so she can be protected because some theoretical plaintiff's attorney is going to come after her, which is not going to happen. But the settlement is really based on, we're going to build up our membership numbers as quick as possible and get as much revenue in. And then they're all going to start dropping off after this is all over and done with. So it was really more of a revenue producing settlement to cut the legal costs and expenses that they were incurring. But they still have a heck of a lot more down the pipe. As far as Alta goes, they don't have that issue yet, but they have no message. There's no message to the public. There's no message to the industry. That's a problem. And that's something that these politicians are exploiting from my perspective. I don't know if Mike, you see that or either Mike sees that, but
yeah, that's the problem. What nobody's understanding is we in the real estate industry or the title industry have no effective voice right now. Okay. There's so much side chatter going on and so much distraction. There is no voice. Yeah. And yes, we're going to be exploited and taken advantage of politically right now. So that ship has also sailed.
All right. Well, gentlemen, let's go ahead and open it up to a little bit of a Q&A. We'll give people a chance to ask a couple questions directly to you. It'll be up in the chat. So let's see if we have anything. I know a couple have come through. Mostly lots of that.
Yeah, there was a question about the MLSs that choose not to adopt the settlement, Marx.
Yeah, as far as I know, the non-NAR MLSs, at this point, only one I'm aware of that has decided to it, and apparently they were under great. There was a lot of inner conflict as to whether to opt in or opt out. They did, in this particular case, they decided to opt in to try to give some consistency across the industry. None of the other ones have, and all of them are pulling the data off the commission data fields off of their website. That is something that they're doing. Some are putting in a concession data point or a rebate data point. It creates a lot more uncertainty and really just forces the DOJ to come in harder, or not, I wouldn't say come in harder, but to significantly intervene to try to create some sort of consistent playing field in their eyes, whatever their model is, whether it's conservative or progressive, or they want something that's kind of uniform. And right now we just don't have that, and we probably won't for a while. And again, you have 50 states, 50 different jurisdictions that, and local jurisdictions that do different things. That's going to be it's a problem that will be fixed. It's just going to take some time.
Marx, could you clarify something? Everyone talks about the NAR settlement. Does that strictly apply to Sitzer Burnett and not include Baton at this point, or the 20 other ones that are out there? Because wasn't it ruled they didn't get the multi-jurisdictional, did they? They
did not get the multi-district consolidation. Only three. I think it's three lawsuits in other states were consolidated in. The multi-district litigation panel rejected the consolidation, saying it was way too premature for that. And so that's why you have litigation going on all over the U.S. So
this so-called NAR settlement that's going to protect and save us all applies to what exactly? That's what nobody wants to be specific about. It's confusing the hell out of everyone.
Yeah,
please elaborate. They need to know that.
I mean, technically, it's supposed to cover NAR nationally for all of these issues, and that's possibly that could happen. I'm having a difficult time seeing this being applied on a national basis when you have other litigations out there. Let's say I bring NAR into Louisiana. How do they get opted in because they want one of the lawsuits to be consolidated in? So there's a lot of civil procedure issues that are creating a little bit of chaos and uncertainty as well. So
we'll take that a step further then. What was settled on the Sitzer Burnett and Baton and the other ones, the three that were combined, they never addressed the issue with commission steering, where agents would steer buyers to listings that had 4% versus 3% co-op offered. That's the next thing coming down. DOJ's all over that, which means, sorry, but one of you attorneys is going to sue on that one next, because that wasn't mentioned before unless I missed it.
No, I think that's what I'm waiting for the DOJ to come in today and file into their intervention in the Burnett case to see. That should give us a clear indication of where they're headed.
Okay.
Whether the judge adopts it or not. I mean, if they adopt it, well, then all these companies that have settled are going to have to now adopt that. There's a lot of moving parts to the settlement that haven't been officially confected. This objector hearing is very important for the to see if the judge is going to accept everything.
My question here then would be, is that grounds for another round of lawsuits because that topic wasn't covered in the other ones? And it's steering, plain and simple. If you don't want to comment because it's who you're representing, I get it, and I'll shut up.
I may see differently on that. But
yeah, if you can't answer it, you can't because of who you're representing right now. But those are some of the concerns that have not come out yet. And that's what we're waiting for next. This is going to drag out a long time.
Okay, next question is directly for Mike about ABAs and how you think that's going to shake out. So what are your comments on that one?
Well, I touched on it a little bit at the beginning, and I think with these changes, there's going to be some scrambling with the consolidation, with the uncertainty, the ancillary income. How are we going to make that up? And I caution everybody out there, this cottage industry is going to kick into high gear for affiliated business arrangements. And don't take yourself from one uncomfortable situation and put yourself in another. When I'm analyzing a potential partner for an affiliated business arrangement, I scrutinize it pretty closely. And I always guarantee before I enter into one that there's enough business there to support it on its own, whether I was involved, whether the broker was involved. Is there enough business to merit a full-blown title agency or not? Fully capitalized from inception, standalone. I just caution people, if you're going to scramble to get into one of these, make sure you have the business and the wherewithal to enter into a title arrangement, because with a greater number of ABAs is going to come greater scrutiny, more policing, more, auditing. And I welcome it. People just need to be careful. I mean, I know we all need to figure out what we do with our shrinking margins. And I do think affiliated business arrangements are going to become one of the key components of that solution. But I do caution that people enter into legitimate affiliated business arrangements, or you're going to put yourself in a worse situation.
Can I add into that? I've done enough of those and had enough over the years. I think one of the problems is going to be you have too many of them out there right now. Everybody's setting these ABAs up for title, lending, and everything else very quickly and very rapidly, not realizing that we've already dropped from basically 6 million to 4 million transactions and still declining. But we have a more important shift, whereas, and this goes back to what clear cooperation was really about, but everybody's always talked about the 80-20 rule of real estate. It's Pareto's theorem, who's kidding who. But that is about 93-7 in most markets as it is. When you switch to whoever controls the inventory, just like the old days when we started, whoever controlled the inventory controlled the market, and clear cooperation and buyer's compensation, agent compensation is out, you're going to have about 5% of the realtors, I don't say realtors, let's say agents and brokers, controlling 90+% of the listing market. And when that happens, which it will, okay, that is where all the business is going to be. So they're going to you control the inventory, you control the buyers and the sales. End of story. Those ABAs that are set up are no longer going to be sustainable with 90% of the brokerages that have them. They will not have enough volume to do it. So like when Mike here is setting up an ABA, you better look carefully, not at what their current business is,
That's
but
right.
what is their business model for the future. Otherwise, that venture is just not feasible. Yeah. And you're going to see a lot of them starting to struggle really hard.
And really fast.
Very quickly. But you know what the big problem is? What's the first thing every business owner does? And I don't care if you're a broker, lender, title, or car salesman, doesn't matter. When times get tough, you start cutting corners and you start skating. And that's when it gets to be a real mess and it affects the whole industry. That's my concern, because we've seen that in the last 5 downturns. Brokers, agents, lenders, whatever, they get desperate, they start cutting corners and skating. And that gets really bad really quick. So I think even from your perspective, Mike, as you said, evaluating very carefully, I think that's the biggest understatement you've made. I think, okay, I think it's going to be much tougher, and you're going to have to be even more careful.
I would say that the environment for affiliated businesses, the enforcement environment is the highest I've ever seen it in my life.
Agreed. I agree.
I mean, I'm still young. I mean, I'm still probably 20, but I would say I think I've had 18 enforcement actions since January of 2023. And out of the 18, 17 of the 18 involved affiliated operations. Now, luckily, all of those companies were set up 100% compliantly. They had their initial capitalization was over $100,000. They had an outside marketing budget. They had full-time employees. They had a website. They had office space. They had signage. They did the core title work. I am seeing I have been seing, though, a lot of these companies that are fly-by-nights that are putting stuff together that, quite honestly, they shouldn't be in business. Some of the stuff that we're seeing, because it distorts the marketplace. So I'm all for more enforcement on that, and not just affiliated operations, but also marketing practices and things that go far beyond what is legal or permissible under RESPO or under state law. So we will see that. The other part to the affiliated aspect is the buyer affiliated operations. So where you have buyer agents that are in these affiliated operations.
Yeah,
I think that to me those are going to be the ones that could probably get the first to drop off the
100%. Agree.
And I do think this new model that we're seeing that really kind of homes.com is kind of facilitating, they doubled down and went all in on this that NAR was going to lose a lawsuit. I think we're going to see in a lot of jurisdictions in the U.S., instead of the buyer paying for the title, the closing, the seller's going to start paying for that. I think you're going to see a change just to help facilitate and make the process a little bit smoother and easier.
You're just talking about a shift in common and customary practices, though, because there's never been any law who has to pay. It's just what is allowable under the IOCs. I agree with that. But that's another little problem that's been stated here as well. We didn't touch on that. So Fannie, Freddie, FHA, and VA just came out with and said, oh, yes, we are going to allow buyer's agent commission to be paid, on the HUD with everything else. But they didn't really say that. What they said was, as long as it's common and customary, we will permit it. That's what they said. Okay, right now it's common and customary. Common and customary is going out the windows, guys. We don't know what it's going to be a year from now if it's still common and customary. So they didn't really make a long-term commitment. This was this wasn't even a Band-Aid. And that whole issue.
I hate to cut you off, Michael, but we are at the end of our session.
Oh, sorry.
Hopefully we can do another webinar. I'm so sorry.
Shut up. Just say shut up, Mike. It's okay.
I'll be nicer than that. But I really want to thank you all for such a rich and informative discussion.